subject matter of today's event, you all know, and I want to thank the Human Rights Institute and RightsLink for having sponsored it. But let me get quickly to the speakers. Maybe a little bit of context. Those of you that have followed the International Criminal Court will know that one of the principles that is often cited as an advantage of the ICC is that the ICC will only take those cases that a domestic court or a domestic government or state is unwilling or unable to handle in terms of the core crimes, war crimes, crimes against humanity, or genocide. So that's called complementarity. So the question is, well, can states do this on their own if the ICC isn't going to handle it? So that's more or less the context of today's discussion, where soldiers for sexual slavery and forced marriage as crimes under international humanitarian law. From 2001 to 2007, Mr. Rapp served as senior trial attorney and chief of prosecutions at the International Criminal Tribunal for Rwanda, ICTR, where he personally headed the trial team that achieved convictions of the principles of RTLM radio and Kangura, and advocates on international justice issues relating to Bosnia, Cote d'Ivoire, the International Criminal Tribunal for the former Yugoslavia, and the ICC. During her time at Human Rights Watch, Ms. Singh has written press releases, briefing papers, and reports on topics including the ICTY, who is a War Crimes Committee. He is an international criminal law specialist practicing in the areas of war crimes, international terrorism, extradition, and human rights law. Toby lectures exclusively, serves as foreign counsel to address the general
Colombia and talking about this topic. As Larry indicated, this subject of domestic crimes domestic trials for atrocity crimes has become a subject of major debate and discussion, in particular because the ICC has this principle that it's a court of last resort. The preference is trials at the national level, and it's only when there's a failure of will and capacity that you go to the international level. Additionally, I point out that with the closure of the ad hoc tribunals, the Yugoslavia tribunal, the Rwanda one where I worked, and the Special Court for Sierra Leone, and with the record of accomplishments of those courts, which have tried more than 200 people, it in my job raised expectations everywhere for accountability. I mean, our people suffered. We had genocide. We had crimes against humanity. We had political violence that took away my father, my uncle, my cousin, my brother in the past. And where is justice in our case? So not only do you have an interest in cases of crimes that are ongoing or that have occurred recently, but you also have increased pressure to have an accountability mechanism. Here today dealing with specifically the protection of the rights of the accused is part of this broader question of what kind of standards are going to be applicable to these trials if they're at the national level, where increasingly they will be. Now, from the point of view of the ICC, we've had a couple of rather interesting cases, and we want these trials, and we want these individuals brought to account, is we want to send the message that if you do the crime, there may be consequences. We want a message sent to President Assad of Syria today, or to whatever other leader might be a victim here, because I know it's going to be a major cause of discussion, and particularly because my office was asked by the Bangladesh government to make recommendations about ways in which their court could meet these international standards and could fulfill these expectations. And I visited there 3 times, and after the first visit prepared a lengthy 10-page single-space letter laying out ways in which I encouraged them to adopt at least rule changes, and if they couldn't do it by rule, statutory changes to meet standards. The particular issues that I raised, one were in the area of substance, and in part this is because this International Crimes Tribunal, which has been established there, is prosecuting so-called international crimes, but doing it on the basis of a law that passed in 1973. Of course, that law was passed after the crimes, which happened in 1971. And in the area of international crimes, it is possible to pass retroactive legislation. But the law has to reflect international. It appears that any murder of a civilian, any rape of a civilian, would be a crime against humanity. Now, of course, there's nothing wrong with prosecuting people for ordinary crimes that have been on the books since time out of mind, for rape and murder. But to call it a crime against humanity, I think, is, and to talk about this as an international crimes tribunal, I think misses the boat, and fundamentally. And on those, I basically, and this was an attempt to be diplomatic certainly, and important in our role as we deal with our own system and everybody else's, noted that Bangladesh is now in the ICC. Bangladesh has had investigators and judges and prosecution counsel and defense counsel at the other international courts, and I've worked with a number of them. I urge them to look at rules that have been adopted at the other courts and put those into effect. At the same time as they made the clear declaration that the rights under the International Covenant on Civil and Political Rights applied to their proceedings. This was particularly important because under their 1973, under amendments to their constitution back in 1973, strangely enough, crimes in this International Crimes Tribunal are not subject to their, actually they get the disclosure 3 weeks beforehand instead of just the judges. They did say there would be victim protection, though it was not very well defined. On the other hand, no interlocutory appeals, no disclosure of exculpatory evidence, no protection of rights during interrogation, and a number of other specific provisions weren't adopted. The fundamental point, however, is that that even those rights that were adopted, and I'm sure we'll hear, there's questions about whether those rights are being enforced or upheld. And that's why at this point, one of our major interests in this proceedings is to make sure that
I'm Senior Counsel in the International Justice Program at Human Rights Watch. And I wanted to start just by echoing what Ambassador Rapp has said, that, with the rise of the international justice movement, there have been increased expectations that there will be accountability for atrocities committed. I think the issues with respect to the capacity of national courts to be able to handle these trials, that can be addressed to an extent with training and engagement sometimes. I think, from our perspective, we really think that it could have been a model for addressing accountability at the national level. And indeed, in 2009, when the government expressed a commitment to pursuing justice for war crimes, crimes against humanity, and genocide committed during the 1971 war under the International Criminal Tribunals Act, as I said, we welcomed it because justice for these crimes was long overdue. But we expressed concerns even at that time about weaknesses. We expressed concern that the resulting process in Bangladesh would lack credibility both domestically and internationally. So why does the credibility of the process matter? That's an issue I'm going to address in a couple of minutes in my remarks, but at this stage I simply want to emphasize and echo what Ambassador Rapp has already said, which is that an unfair process, especially for these sensitive and politically charged crimes, jeopardizes one of the key goals of the trials, which is to uncover and establish the truth behind their commission. And I would also argue that an unfair process runs the real risk of eroding confidence in the rule of law and with the international obligations of Bangladesh. Now, in 2011, the government amended the rules of procedure governing the tribunal to address some of these concerns. And again, as Ambassador Rapp already mentioned, now the accused has the right to the presumption of innocence, a fair and public hearing with counsel of their choice, and the right to apply for and be granted bail. The prosecution here bears the burden of proof beyond a reasonable doubt, and the changed rules also allow the tribunal to ensure that the changes made by the government. It's Human Rights Watch's position that the ICT legal framework still falls far short of international fair trial standards in other areas as well. A couple of examples. So as Ambassador Rapp has mentioned, the current definitions of war crimes, crimes against humanity, and genocide in the Act are vague and should be amended to more clearly articulate the relevant definitions as they existed under international law at the time of their commission. Also, the tribunal's legal framework prohibits an accused from questioning the impartiality of the tribunal, which essentially forecloses the rights of defendants very seriously. This recommendation has gone unheeded. Now, unfortunately, the practice of the tribunal has only heightened our concerns about the lack of independence and partiality, and ultimately the fairness of the process. For instance, the chairman of the tribunal has been identified as a lawyer who wrote a report in 1994 accusing the current suspects of the ICT of war crimes. This report forms a key part of the prosecution evidence, which of course raises concerns about his impartiality when it comes to adjudicating those very same crimes. Recently, the bench allowed the prosecution to introduce 15 witness statements without liability to the defense. First, late last year, we expressed concern over the harassment of defense lawyers by state officials, which included the threat of arrest. Several witnesses and an investigator were similarly harassed by police and threatened with arrest for cooperating with the defense. And these threats were not idle. Indeed, a key defense witness was arrested, and a journalist referenced a recent cabinet decision which approved another amendment to the draft of the ICT Act, which effectively reduced the time period for appeal from 60 to 30 days, appeal of a tribunal's judgment. So, in summary, the legal framework of the ICT and the practice of the tribunal have cast serious doubt on the impartiality and independence of the justice process. So now I want to spend a couple of minutes discussing the dangers of pursuing a flawed justice process in Bangladesh and beyond. So why do these flaws even matter? Well, as I said before, no one would deny that serious crimes were committed during the 1971 independently to render justice impartially on the basis of the law. That is what protects people from the abuse of power by the state. Threats to the independence or impartiality of the judicial system and the damage done to the rule of law leave ordinary citizens vulnerable to the whims of the state. Concerns about the failures of the legal framework and the practice of the ICT to date to safeguard the defendant's due process rights risks eroding the rule of law in Bangladesh over the longer term. So I began my presentation with an outline of the efforts we've made to engage the Bangladeshi government and make constructive maintain some engagement with the government and on these issues. Key international figures with a presence in Dhaka, notably the EU and the UK, have failed to do just that. Governments should be monitoring the proceedings, and I welcome Ambassador Rapp's efforts to establish a monitoring process. I think it's really important. But they should also be making clear public statements about the risks to the process. Even if there's limited...
Defence attorney, I'm in the enviable position in not really having to say very much at all, because my two colleagues have effectively set out how dangerous a precedent is being set in Bangladesh and, ironically, is prosecuting war crimes in Bosnia before I got involved with this. And I got involved with this because I could see that there was an element of danger, and that as an international lawyer specialising in this field, the need to set a system to bring an end to impunity is very, very important. There's no getting away from the fact that this was a very brutal conflict. A large number of civilians suffered. Personal view, as I've expressed many times, certainly over the last few months, is that this should be the subject of an international process. It's very dangerous to leave this in the hands of a very emotional government where everything focuses on the War of Liberation of 1971, and any opposition to this process is considered to be anti-liberation, anti-government. And to give you an example, like the ambassador, I travelled to Bangladesh on a number of occasions. I was allowed into the country 5 times, and I spoke very critically of this process. And on the 6th why, I was told it's because you're defending war criminals. I tried to argue that they are suspected, not convicted, but that, as I learned, is something that really has no value in Bangladesh. Both the 2 previous speakers have spoken about the amendments to the legislative framework, and they both focused on the very important change of having a provision dealing with the presumption of innocence in the law. Well, I'm afraid that all of the amendments that have been made have absolutely no practical application whatsoever. And the presumption of innocence is one of the most important concerns that we have. There are repeated statements setting a very dangerous precedent. Already we have seen, for example, a delegation from Uganda who recently travelled to the tribunal to observe the practice. Because this really is the only national prosecutions for crimes of this kind. And so the Ugandan authorities travelled to Dhaka to observe the practice. Immediately after their visit, members of the Bangladesh government started the rest of the day to set out all of the concerns that we have. And so I just want to focus on a couple of the most egregious aspects of this legislation. As Ambassador has already stated, he, on the invitation of the Bangladesh government, made a series of recommendations. Now, very few of those recommendations have been implemented, and those that were implemented have absolutely no practical effect. Made as a result of the Ambassador's recommendations, there has been no real practical effect because the tribunal has refused to release any of the accused on bail on the sole ground that they are not sick enough. This would indicate that you can only be released on bail if you're sick. One of the accused is 90 years old, is very ill. Another accused suffered a heart attack whilst in custody. Unfortunately, these two individuals are not sick enough to be granted bail. There was also reference to the concerns of disclosure and the investigation. Notice of the type of questions that would be put. We were also not entitled to have a lawyer present with the detainee when he was interrogated by the investigators. We were allowed to have a lawyer in the same building. He was not allowed to inspect the room where the interrogation would take place, nor mention is the right of review. Now, it's right to say that there is no right of interlocutory appeal. There is no right of judicial review. The only challenge that can be brought is to request the same judges who issued the decision to review their own decisions. We've submitted 27 so far. We are yet to be successful. There is a right of appeal against conviction and sentence, and the government has repeatedly stated that this is why trials meet. The reduction of the period to appeal from 60 days to 30 days is further evidence that there is a timeline. And the timeline is 16th of December. We expect, as the government, members of the government have announced publicly, that three of these cases will be concluded this year, and the remainder will be concluded by the 25th of March next year, another important date for Bangladesh. One of the issues raised by Pam was the impartiality of the tribunal, and she mentioned that the chief judge was previously involved as a member of an investigative commission that had conducted investigations into these matters, do not receive reasoned decisions. And one of the main problems with the question of impartiality is that not only do we have a judge sitting who has already prejudged these cases, and I would like to add that the investigative commission in the early 1990s, it was concluded by a people figure in this commission. But we cannot challenge that. But the other area in terms of the impartiality is that the prosecution formulates the charges, but it is the judges who frame the charges, who actually draft the charges. They deal with all preliminary matters. On was the comparisons between a system such as Bangladesh and Bosnia, where my previous experience was. So I'm going to have to do that very, very quickly now, and hope that I'll ask some questions on that, so we'll give you an opportunity to speak about what I've actually brought in to speak about. The situation we are faced with in Bangladesh is that we have sat back and allowed this process to continue. Organisations such as Human Rights Watch, Ambassador Rapp's office, Amnesty International have made repeated proposals for change, and nature of these crimes, and it is very difficult for any judge or prosecutor to distance himself from something which he would have suffered personally, or he would have lost a family member during that brutal armed conflict. That was why there was such a need for an international justice system. The same is required for Bangladesh. We have repeatedly stated that it is not a question that there should not be a tribunal. There should be a tribunal. There should be trials. Any following trials that fail to uphold any proper standards, then this will not be closing the impunity gap.
I've had its representatives here, you might, and if not particular, how to monitor this sort of thing.
Make sure that the process is monitored on a day-to-day basis. Our embassy there is busy on a great many things with our relationship with the country, and certainly at the moment with the situation of the Rohingya that are in refugee status in eastern Bangladesh. There are lots of things that are doing. We follow the trial as closely as we can, but not as much as a program that would be there every day and would be, and of course, I've been to trials and I've seen how they go. It's not the easiest thing for an outsider to monitor because generally the witnesses are examined in Bengali, but then argument is often had in English and there's no interpretation back and forth. So we're looking to see about having young attorneys or law students who are from Bangladesh writing reports that basically describe what's occurring so that others can read these reports and comment on them, and that this can lead to pressures to make improvements in the actual enforcement.
Obviously, the ambassador has spoken about his involvement, and Pam has spoken about what Human Rights Watch has done. What we've been focusing on more recently is engaging the United Nations in this process. Now, we've spoken to the ICC. We recognise that the ICC doesn't have jurisdiction over these matters because they're from 1971. But we do believe that the ICC has a responsibility group on arbitrary detention. And very recently, actually just before the summer, there was a hearing at the working group session where I was asked to present the Bangladesh case. And it was recognised by the working group that even though they had previously given an opinion to say that this process is arbitrary and breaching international law, it warranted more than just a written opinion. It warranted a country visit. We have followed that up with the Special Rapporteur on Independent Judges, and we have followed it up with the Special Rapporteur of Summary Execution. What we would hope is that the United Nations, through the Human Rights Council, recognises the gravity of the situation, and we would hope that there would be sufficient support to at least send a fact-finding mission to Bangladesh to observe the practice, because we're no longer talking about a situation as has been very little engagement, because the question is quite often asked, why should we really care about a number of individuals, a handful of individuals that are going to be put on trial in Bangladesh? What is our interest? And so what we have requested the international community is to recognise the very dangerous precedent that's been set. And we believe